Hello, friends. I welcome you all to this 39th session of Law of Evidence. And today we are going to start a new chapter, that is, chapter 7 of uh, Indian Evidence Act. It is part 3rd. So, it is part 3. You should remember that what is contained in part 3. It is about production and effect of evidence. Production and effect of evidence. And chapter 7 is about burden of proof. So, today we will be discussing section 101 to 103, and as usual, let us have a brief overview. Today we will be studying what is burden of proof, what is onus of proof, and what is the differentiation between the two. Many a times in examination also, the difference between the two has been asked. Now, first of all, we'll give a bare reading of the three sections, section 101, 102, and 103, and then we will come to the two questions which we have framed for the day. So, what it says is burden of proof, section 101. Whoever desires any court to give judgment, remember the word judgment, as to any legal right or liability dependent on the existence of fact which he asserts, must prove that those fact exist. When a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. So first we'll see this part where the definition of burden of proof is given. That what is the burden of proof? Burden of proof means when a person is bound to prove the existence of any fact. And why he is bound to prove the existence of any fact? Because he wants a favorable judgment, or he wants from the court a judgment in his favor. So section 10 simply says that anyone who wants a judgment in his favor, he will have to prove, or it is his um, burden, or he is bound to prove those facts on which he wants the judgment before the court. So, if like we will see the illustrations attached, A desires a court to give judgment that B shall be punished for a crime. So, suppose police wants that this is a criminal and he should be punished as he has done the crime. So as police is asserting something, so it is on the police, or police has got the burden of proof that he is a criminal or he has done a particular offense. A desires a court to give judgment that he is entitled to certain land. B denies it to, uh, to be true. A must prove the existence of those facts. So suppose this is a particular land and it is in possession of B, and A says that this is his land. Now, as A has asserted it and B denies this fact, then as A wants a judgment in his favor, so it is duty of A to prove that. Now, burden of proof lies on A. So anyone who wants judgment in his favor has got the burden of proof. Now, one important case is there, that is Benazir versus SJE. Benazir versus Vela Yudhan. This is 1998 Supreme Court. Now, in this case, it was held that suppose there is a landlord, and this landlord has given certain premise to a tenant. Now, the landlord wants that this particular premises for his own personal use, there is a necessity for him, and therefore he want to evict this tenant. Now, as landlord wants a judgment in his favor, so it is the um, burden of proof lies on the landlord to establish that he is genuinely in need of the accommodation, or there is a bona fide personal need. So the burden of proof lies on landlord as such. Now, section 102. Section 102 would seem to be related to, would seem to be same, but there is a fine difference. What it says, on whom burden of proof lies, rather it shows on whom onus of proof lies. The burden of proof or onus of proof in a suit or proceeding lies on that person who would fail if no evidence at all were given on either side. So if there are two party A and B, remember the word no evidence, and A claims certain thing from B in court of law and B denies it. Now A goes to the court. So if no evidence is given either from A side or B side, then in this case certainly as A is asserting something, he will lose the case. So the burden or onus of proof lies on A. That is, if no evidence is given from either side, then the party who would fail will have the onus of proof. So A sues B for a land of which B is in possession, and which A as so there is a land and land is in possession of B. A claims that this is his land, which A asserts was left to A by will of C, B's father. So B's father was C, and A asserts that he has given a will in his favor. If no evidence were given on either side, B would be entitled to retain his possession. Therefore, the burden of proof lies on A. So, suppose there is a land and this land is in possession of B. Now, A claims that this is his land. Why? Because C, who was father of B, has made a will in favor of A. Now, A asserts it in court, but he gives no evidence. So, as no evidence is given, then the contention of A would fail. Therefore, the onus of proof lies on AR. Here also, we will do one case law, that is Subra Mukherjee. Subra Mukherjee versus Bharat Coking Coal Limited. This is of 2000 Supreme Court. Now, in it, that there was a document, and it was claimed that this document is a bogus document. Suppose there are two party A and B. Now, A claims it to be bogus, while B claims it to be genuine. Now, here the first, if no evidence is given on either side, then the contention of B would fail, because first of all it is the duty of B to establish the genuineness of the document, and once B establishes the genuineness of document, then A has got the onus of proof of proving it to be bogus. So where the issue was whether document in question was genuine or sham or bogus, the party who alleged that fact had to prove nothing. So B who alleged that it's bogus, it it does not have to prove anything, till the party relying on the document, till B who is relying on this document establishes the genuineness in the first place. So, first it is duty of B or the party who is relying on this document to prove that it is genuine document, and then only it is the duty of the owner shifts on A to prove that it is a bogus. Now, let us come to section 103, burden of proof as to particular fact. So, burden of proof as to any particular fact lies on that person who wishes the court to believe in its existence, unless it is proved by any law that the proof of the fact shall lie on particular person. So, suppose the question is, if there is a particular fact, then on whom that burden of proof to prove this particular fact would lie? So anyone who would want the court to believe it, on him the burden of proof will lie. So suppose same A prosecutes B for theft and wishes the court to believe that B admitted to the theft of to C. A must prove the admission. So where A wants the court to believe a particular fact, then it is for A to prove those facts. Now, these three 101, 102, 103 is actually about the um, proving a particular point with respect to court. So, we can also write it as burden of proof, or it can also be said as balance of payment. Balance of payment. BOP is famous for it. So this is section 101, this is section 102, this is section 103. This is how we can remember it. So B, it is burden of proof, and on whom burden of proof is? On the person who wants judgment in his favor. Then O stands for onus of proof, and on whom onus of proof lies? If no, who would fail if no evidence is given on either side. This onus first two words, if you opposite it, then it becomes no. If you invert it, then P stands for any particular fact. So reverse it P, it becomes B. So who wants the court to believe on that particular fact? On him that burden of proof would lie. Now, what is the difference between the two concepts, or what is this concept of burden of proof and onus of proof? So, burden of proof means obligation to establish a fact. So, burden of proof means obligation to establish a fact. Now, on whom it would lie? So, certainly it will depend upon the type of case we are. So, if it is a criminal case, then as we all know, burden of proof would lie on prosecution because of the famous um, idea that a person should be considered to be innocent until unless he is proved guilty. So, burden of proof in criminal case would lie on prosecution. In civil case, the burden of proof would lie on plaintiff, except in certain circumstances. Now, another term is onus of proof. Now, onus of proof is regarding a particular stage. That is, at a particular stage, suppose it is plaintiff and it is defendant. So plaintiff has given certain facts in proof of his assertions. Now the onus of proof from P has shifted to D to either accept it, and in case he accepts, then P will succeed, and in case he denies, then it is on D now to disprove these facts. So the onus of proof has again shifted to D. Now once D has established this fact, then again onus of proof shifts on P to add to what assertion he has made. So this way, at any particular stage, the onus of proof shifts continuously. Now, what is the difference between the burden of proof and onus of proof? So basically, there are three differences. One is that the burden of proof is fixed. So in criminal case, as we saw, in criminal case it is on prosecution. In civil case it is normally on plaintiff. While onus of proof, it constantly shifts. Why it shifts? Because it relates to a particular stage of the trial or the suit. While this is for the whole case, as it is a particular stage. So we have seen that it shifts from plaintiff to defendant, from defendant to plaintiff on that particular point. But as far as the whole case is concerned, there is burden of proof. And what is the burden of proof? To establish all the facts that would lead to judgment or favorable judgment. While it relates, onus of proof does not relates to all the fact. It relates to only one particular fact at a time. So we have seen that though the term seems to be connected or seems to be similar, but there is a difference. What is the difference? Burden of proof, and this burden of proof is related to section 101, while onus of proof is related to section 102. So what it says is that burden of proof is fixed while onus of proof constantly shifts. Burden of proof is for the whole case while onus of proof is for one particular stage. Burden of proof means that a person has to establish all the facts to give a favorable judgment, to get a favorable judgment. While in onus of proof, one has to prove only one fact at a time. So, and one important case law also I want to discuss with you, and that is Pushpad Mishra. Mishra versus Arjuna Mishra. It is 1992, Madhya Pradesh. Now, in this case, it was held that even if it is, say, very difficult to prove a particular point, then also the burden of proof would lie on the prosecution. For example, suppose wife alleges that husband has committed an adultery, and on that ground, wife seeks a divorce. Now, in this case, this wife claimed that as adultery is done in closed rooms, so it's very difficult to prove it. So, yet it is still on the burden of proof would lie on W. Though it is very difficult, yet the burden of proof would lie on the wife or the claimant that the husband has committed the adultery. So, where a wife in a divorce petition alleged adultery on part of husband, it was held that the burden of proof was upon wife to prove that fact, and it was no excuse to say that it was virtually impossible to procure evidence of that fact. So this was held in Pushpad Mishra versus Arjuna Mishra. That is, a person cannot be relieved of his burden of proof or burden of proving a fact, even if the fact is such that it is very difficult or impossible to prove it. So that's all for today. We have seen the three things that section 101 says, that who has got the burden of proof, a person who wants judgment in his favor. Section 102 who says who has got the onus of proof, a person who would fail or party who would fail if no evidence at all were given on either side has got the onus of proof. And section 103 says who has got the burden to prove a particular fact. It is that person who wishes the court to believe in its existence has got the burden of proof to prove that fact. Burden of proof means obligation to establish a fact, and onus of proof means at a particular stage to prove a particular or obligation to satisfy the court as to existence or non-existence of certain fact. Burden of proof is fixed while onus of proof constantly shifts. Burden of proof is for the whole case while onus of proof is at a particular stage. Burden of proof finally leads to a favorable judgment while onus of proof leads to establishment of one particular fact at one time, and it's no excuse to say that or burden of proof cannot be done away by saying that it is rather difficult or impossible to prove a particular fact. That's all for today. Thank you, friends.